like to bring up Edward Canavan, who is our Director of National Compliance with the Workers' Compensation Practice, to introduce our next speakers, Richard Jacobsmeyer and Michael Sullivan. Eddie?
Good morning, everybody. It is my pleasure this morning to introduce to you Richard Jacobsmeyer and Michael Sullivan. Richard is partner with Shaw, Jacobsmeyer, Crain, and Claffey. He's been a certified workers' compensation specialist since 1981. During Richard's career, he has handled claims for both injured workers as well as employers and carriers. He currently serves as amicus counsel for the CWCI and is also a panelist for the California Self-Insurance Association, the California Coalition on Workers' Comp, and the California Applicant Attorneys Association. Workers' Comp Executive Magazine named Richard as one of the most influential people in workers' compensation in 2010. He's part of the Comp Guys online educational program, providing insight and analysis to users on the web. He also maintains a legal email update on case law. Michael Sullivan from his firm, Michael Sullivan & Associates, specializes in workers' compensation as well as labor and insurance litigation. He's a member of the State Bar of California Workers' Compensation Section, the California Workers' Compensation Defense Association, the Public Agency of Risk Management Association, the California Self-Insurers Association, as well as a noodle group comprised of risk managers and attorneys charged with advocating for positive change in the California workers' compensation system. He's a co-writer of Sullivan on Comp, a 12-volume publication that provides analysis and insight on California workers' compensation law. He holds his Juris Doctorate from Hastings College of Law, University of California, San Francisco, and graduated magna cum laude from Loyola Marymount University with a bachelor's degree in philosophy. It is my pleasure this morning to welcome both Richard and Michael to our forum.
Okay, good morning.
Good morning.
I'm the Richard of the Richard and Michael Show. And most of you know me as Jake Jacobsmeyer. And our job today is to try and bring some structure to this sort of massive change of workers' compensation. And I would like to point out, tailing or sort of topping off Martin and Jason, before 1991, we didn't have workers' comp reform. In 1990, employers got involved in workers' compensation, and that's when we started to see things other than simply rate increases and benefit increases in workers' compensation. Up until then, the only thing that ever happened is you raise temporary disability, you raise permanent disability, and you might tinker a little bit with the system, but it was basically applicant attorneys and insurance companies who would negotiate rate increases, and they'd be implemented in a package, and we were on. In 1990, we started seeing the impact of employers, and it's grown to the point where in 2012, we literally have a reform package that involves employers and labor and is done almost incidentally without much input from the applicant's bar. So this is a revolutionary concept in what we've done. It's an evolutionary concept because it's been going on since 1990, but this is sort of the culmination of bringing workers' compensation back to employers and labor. And this is, at least in my experience, the most massive workers' compensation reform that we've ever had. It touches on far more code sections, has a bigger impact than anything that we've seen in the past, along with something that labor wanted, which was benefit increases. So we're going to talk about we're going to break this down into a number of different areas. Permanent disability benefits, which includes both rate increases and changes in the rating schedule, return to work issues, supplemental job displacement benefit. There's some significant changes there. Independent medical review, it's already been referenced. Independent bill review, lien reform, which is huge in California. Jason said you talk to other people about other states about liens, they go, what are liens? What do you mean liens? Well, California has had a unique lien problem that this will address. MPN reform, medical treatment and fee schedules, and then litigation and procedural changes. And this isn't all of it. There's stuff in here that we can't even touch because there's so many little individual components to this and so many small tweaks that are designed to correct problems, some of which existed since the early 90s. As part of this reform, there's a lot of attention to detail in this process. So first we're going to talk about the permanent disability rates. We've had both rate increases in 2013 and 2014 that affect permanent disability, and then we're going to have a new permanent disability rating schedule, or at least a new permanent disability rating process. It's sort of questionable whether we'll see a schedule, but we have to see some things. Some statutory embodiment of the Guzman decision, permanent disability under Labor Code Section 4662 that's specifically placed now in our new code section, and then some limitations on specific impairments that we didn't have before. So the rate increase is probably the easiest thing to talk about. In 2013, we're going to have an increase in the minimum permanent disability rating. Permanent disability rating goes from 130 to 160. The maximum stays the same for 2013 up through a 54% permanent disability rating. And while it looks like there's no rate increase or no increase in benefits below 55%, in reality there is, and that's something Michael will talk about in just a minute. For ratings between 55% and 70%, for those of you who don't know, 70% represents a break point where we get into life pension cases. And we've traditionally, at least for the last 10 to 15 years, had a change in the benefit structure at 70% because it involves life pensions. So from 55 to 70%, the benefits will be increased from $230 to $270 a week, with the minimum rate staying the same at 160, and then for injuries above 70%, we jump it from 270 to 290. Not a big increase, but we also, when you hit 70%, we jump up the weeks in terms of payment of benefits dramatically. And then in 2014, we make it all simple again. We have one minimum rate and one maximum rate, the minimum being 160, the maximum being 290, and every benefit will be paid on that basis. And so this is kind of what the structure will look like as we get into 2013 and 2014. Now, it's important to remember that when we give somebody a permanent disability rating, what we're giving them is the specific number of weeks that they're going to get for their permanent disability, not necessarily a dollar figure. It's a number of weeks, and we multiply that by their earnings with these minimums and maximums, the minimum being 160, the maximum being 230 before 55, 270, and then 290. So it's the weeks that matter. And if your earnings aren't enough to get you the maximum, but they're above the minimum, you're going to get a number in between the lowest amount and the highest amount. So that's how the permanent disability rate structure works and how we look at permanent disability. So if you look at, for instance, these rates, up in 2012, the numbers look the same from 10% to 50, and then you can see at 60 there's a jump, $14,000 jump in 2013, up to $101,000 in 2014. So the increases are going to be substantial when we get to the permanent disability rating. So this is what labor wanted. They wanted increases in benefits, and this is what they get, is the increase in these benefits. And now I'm going to have Michael talk about the new permanent disability rating portion of it.
Yeah, you know, I think it's important to recognize that permanent disability is going to increase gradually, right? If you look at, I think, 2/3 of all the changes in SB 863, they apply to all dates of injury as of 1/1/13. So there's the Lien Reform, there's the plugging the holes in this ubiquitous change in various parts of the code. And they all take effect immediately on 1/1/13, going back retroactively. But the benefits portion of the bill just goes forward. So what's going to happen is we're supposed to see the savings on the other stuff now, and then dates of injury 1/1/13, dates of injury 1/1/14, there's an increase in PD. So it goes up little by little over the next few years. But as Jake pointed out, that's just one part of the change, the rate increase, the weekly amount that we pay out. That's just one part of it. The other part of it is they eliminated the FEC modifier and the rating string and replaced it with a simple multiplier. Now, what they call it is a new PD rating schedule for dates of injury on or after 1/1/13. And it really is a new PD rating schedule, but it operates a lot like what we've got now. First of all, you take your AMA guides, right, and you figure out your impairment percentage, and you still do that. You still have age and occupational modifiers, although in a minute I'll tell you there may be some changes in that. But they took away the FEC modifier. They said, we're not going to do that anymore. And the FEC modifier, was created by the administrative director after extensive studies, and they studied the effective types of injuries on different jobs and different body parts. And the FEC modifier was a reflection of your loss of earning capacity, supposedly, as an injured worker, right? They took that all away. They changed the definition of permanent disability to eliminate this idea of earning capacity altogether. And instead, they just added a multiplier of every impairment of 1.4, or a 40% increase in every basic impairment. Now, for some types of injury, under the FEC multiplier, you either went plus 10% or plus 40% or somewhere in between. So for most cases, this represents a significant increase. And the numbers we saw on the last slide, they're only part of the story. This 40% multiplier to every impairment percentage is a big increase and a big part of how permanent disability was increased. I don't know, what, 30, 50%, somewhere in there, probably.
Yeah, I think we'll let Mark talk about how the numbers actually go up and how much the additional costs are.
Yeah. So anyway, as Jason was saying earlier, originally we had this dream, we would simplify permanent disability, we would eliminate the rating string. That didn't work. We got rid of the FEC modifier. That was, I guess, good. And what we got now was sort of a new rating string. We also dreamed that we would no longer have a rebuttable schedule, right, in any way. And that was a dream, too. That's a dream that did not come true. When we went to meet with labor, I wasn't there, when someone else went to meet with labor, that was just a non-starter for them. And so how does rebutting the schedule work in this environment? Well, first of all, the Guzman case, the Alvarez-Guzman case, has actually been codified. It actually says it in the labor code now. You can rebut the impairment rating, right? You can still rebut that part of the string, that impairment rating. What about Ogilvy? Well, Ogilvy is something we talked about a lot last night, actually, argued about last night.
Just so you know, I think Ogilvy's gone. Well, for injuries after 1113, I think the changes in the new permanent disability rating statute, which, if you recall, prior to 1113 said that we will determining percentage of partial permanent disability or permanent total counts will be taken in the nature of the physical injury or disfigurement, occupation, and his or her age, with consideration being given to, before 2005, diminished ability to compete in the open labor market, and from 2005 to 2012, diminished future earning capacity. We no longer consider diminished future earning capacity or diminished ability to compete in the open labor market. And with the removal of that language, it looks like rebutting the actual rating, the final number, becomes more difficult because we haven't anchored it in anything. We haven't said we're measuring anything any longer. We're simply created the schedule where we calculate a permanent disability, which is prima facie evidence of what the disability is, and that's what we use. And if that's the case, it means that all the vocational testimony for rebutting the schedule or other measurements for rebutting the schedule outside of probably Labor Code Section 4662 no longer exist.
Yeah, I agree with Jake, but I'm not as certain that it's all the way gone. My concern is that, look, I mean, obviously if there's no DFEC modifier, there is no Ogilvy for purposes of rebutting that part of the rating string, which was the original purpose of Ogilvy. I'm concerned about the language in Ogilvy 3 at the Court of Appeal, which referred to rebutting the schedule as a whole, made reference to the LaBeouf decision. If you can show that you're not, able to be rehabilitated, you can rebut the schedule. There's also an addition, is it 5307, I think it is, or 5703, where the vocational rehabilitation experts' reports are now legitimized as evidence at the trial level. Their only purpose is to rebut the schedule, as far as I can see. There's a $120 million fund. So I think I think you'll agree, we're in a volatile environment on this issue. So we'll have to see how that all pans out.
We could probably spend another hour going over this, arguing about which of us is right about this, but we're going to go ahead and move on.
Right, fair enough. All right, so then another thing that we really did get done by SB 863 is this limitation on specific impairments. We all have seen it, right? There's some applicants' attorneys' firms that have clerks that do intakes, and on every claim, on every application, they had psych disorder, sleep disorder, sexual disorder. Why did this happen? Because after SB 863, PD was lowered, and applicants' attorneys saw this as a way to increase PD, regardless of whether there was merit to it. Well, now the rules changed, and there's an actual rule now in the law that says that you can't add on these impairments if there's an underlying physical injury. If it's an underlying physical injury, you can't add on sleep, psych, or sex disorders, which should put a big dent in this overall practice. Now, we need to understand a couple of things. One is that this is a circumscribed rule, and also that there is a set of exceptions. Exception 1, if you're a victim of a violent act, or you have direct exposure to a violent act. That's language that comes from Labor Code section 32A.3, which refers to the predominant cause defense, and if you're a victim of a violent act, it goes down to a substantial cause. So we have a limited amount of case law interpreting that. What we have no case law interpreting is this term catastrophic injury. If you have a catastrophic injury, this rule about prohibiting add-ons doesn't apply at all. So, what's a catastrophic injury? I'm sure we'll be litigating that. I have an old saying that tragedy is when I cut my finger and comedy is when you fall into a hole and die. So, what a catastrophic injury is going to be something, I visualize a case with a 10% knee PD and then a 90% psych add-on, which is prohibited. The only way that applicants' attorneys can get there is if they prove this up, so we'll have to see how that goes.
Now, my take on the sexual dysfunction and sleep disorders, this is really a public health measure, because since 2005, California injured workers have been plagued by an epidemic of sleep disorders and sexual dysfunction that they never used to have, and this is intended to relieve them of having that obligation. But one of the other things that this does, besides getting rid of the compensation element along with these, it eliminates medical legal expenses, because for every sleep disorder and every psychiatric disorder and every sexual dysfunction disorder, you're talking about getting medical legal evaluations, sometimes 3 different medical legal examinations at anywhere from $850 for the really inexpensive ones to $2,000, $3,000 for some of these. So these we're getting, and I have cases where I have applicant attorneys from the moment the file opens up, they're asking for 4 different medical legal evaluators. So this should eliminate some of those, 2, 3, 4, and sometimes each side getting them if it's a possibility. Applicant attorneys frequently would go out and use a treating doctor to get evaluations. You'd have to object, go out to the qualified medical examiner process. So this is a litigation saver, not only in terms of the cost of the benefit, but also in terms of the cost of litigation for attorney's fees, medical legal expenses, the intensity with which you would get medical records, the extra time spent at depositions going over the applicant's sexual history, which you can imagine was the most fun in the entire world. Not having to worry about these things is a huge issue. So from our standpoint, that's a big deal. It is also important to remember that these are just affecting permanent disability, not medical care. So injured workers can still get treatment for these conditions. We're not saying they're not injured. We're just saying that there will be no compensation for permanent disability on them. So that's an important distinction. They can get temporary disability medical care, potentially dependency benefits, or issues which can arise sometimes out of psychiatric. We're not saying they're not injured. We're just saying that you're not going to get compensated for permanent disability on these specific functions.
Yeah, that's right. And also it has to be derivative. It's a very limited thing, right? It's got to be a compensable consequence, psych, sex, or sleep disorder from an underlying physical injury. You can still have CT psych claims, right? You can still file add-ons. You just can't get the permanent disability for them. So that's an important distinction. So listen, why was this done? Why was all of this done? Well, Jason and Martin alluded to it earlier. There was a lot of anger, even vitriol in California, about the way the reduction in permanent disability went down after SB 899, because it wasn't part of the statute. It was part of an administrative action that reduced PD by about 50%. And that was something that was going to happen to us. It was going to go up after Jerry Brown got elected. So this was done to deal with that. On our side, of course, we needed to reduce litigation. A world without lawyers is not a world I want to live in, but I'm sure it's something that you might learn to live with over time if you could, at least to reduce the role of lawyers. And so this, elimination of Ogilvy, or at least substantial reduction, this need to always allege unmeritorious body parts, all of this should operate to reduce a litigation and environment in workers' comp. That being said, I'm not so sure the mission is totally successful because applicants' attorneys now can just send it off to a voc rehab expert to try and rebut the schedule. We have to pay for it. I don't see a whole lot of reason that they won't, if the facts at all indicate that they should, especially because they now can't pyramid. We have an uncertain environment in regards to things like OLV, the $120 million fund, and we'll have to see whether the expected reduction in litigation actually occurs.
Yeah, I have little doubt that we're going to see a reduction in litigation. I think it's hard to quantify. We're going to have a hard time figuring out till we see how these things work out. We do, and one of the things we had in SB 863 is this language that says that in enacting subdivision C, which is involving the sexual dysfunction, psychiatric sleep disorders, the legislature intends to eliminate questionable claims of disability alleged to be caused by disabling physical injury. That's the kind of language that the courts, not so much at the trial level, but the courts will look at and say, this was intentionally done, and we need to effectuate what the legislature intended to be done. So we've got some good, helpful language in the statute itself that should give us some real arguments on this. Oops, now I need to go backwards. Okay, return to work supplemental job displacement benefit. This has been, the whole area about return to work issues in California workers' compensation has been one of the most confusing areas that we've had. The question of when you add on the 15%, what part of the benefit applies to, has been a real thorn in the side. It was an interesting concept as part of SB 849, but it's turned out to be a very problematic issue. And one of the reasons it's been problematic, and one of the reasons why initially labor was unwilling to give up the concept of the 15% increase, is because their employees got the benefit. Even those people who went to work, employers rarely ever made the offer of alternative or modified duty because you had to do it within very tight time frames. Half the time we didn't have the information to do it. And as a result, the offers were never made. People would go back to work and they'd still get the 15% increase. So from labor's standpoint, taking it away was a takeaway. The employer's standpoint, it wasn't working. So the question is, what do you do with it? And what came up with, it's interesting because there were several earlier versions of the bill. The last one I saw had the 15% increase in it, but no decrease. Basically, labor saying, we want that. That's a benefit for our membership. And in the final bill, what we came up with is the 15% is gone altogether. We don't have to worry about it, increasing or decreasing permanent disability for injuries after 1/1/13. And this is one of those things that affects only injuries after 1/1/13. And instead, we have this other thing. And I call it a thing because we're really not sure what it is. It's $120 million. It's going to be paid for by employers. It's going to be part of the surcharge for employers for operating the workers' compensation system because employers now pay for the DWC to function. And there will be a fund created, and the DIR is charged with creating a system for distributing this $120 million to injured workers, for those injured workers who have a diminished earning capacity that is not reflected in the permanent disability rating or a greater loss in their earnings. And so this is going to be up to the state to figure out. It's really not our issue. We're not going to litigate these issues. That's one of the good things about it. Your defense attorneys or your claims adjusters are not going to litigate or administer this benefit. It's all going to be done by the state. So they'll have to create the system, figure out how to give money to people in a way where they don't take the money and then go back to their regular job, because that's what we saw happen a lot with voc rehab, and come up with a system for compensating them. So this is going to be designed. We haven't seen it yet. I don't think we even have an outline yet of how it's going to work. But in the final analysis, this is a pot of money that's created that you're not going to have to litigate. There may be vocational experts used in this process if applicant attorneys become involved in it. So that's one of the possibilities for using vocational experts. Now, the other thing we did is we restructured the supplemental job displacement benefit. For injuries before 1/1/13, we had this multi-tiered where you got a $4,000, $6,000, $8,000, or $10,000 benefit based on your level of permanent disability. We simplified it by making it a single structure at $6,000. So everybody who's eligible for the voucher gets a $6,000 voucher. More employees are going to be eligible. In order to be eligible to receive this voucher, you simply have to have a permanent disability award. So it's going to be interesting to see how that pans out, because one of the things that we do know, I would go and do training classes at claim shops and see how many people have actually had somebody ask for a voucher, and maybe one or two people would raise their hand. As a practical matter, almost nobody used the voucher. It's one of the benefits that was almost never used in the system. More employees are going to be eligible for the voucher. The voucher has to be offered at an earlier stage than it was previously, basically 20 days after the time for making an offer. And one of the things that really happened is we got a statute of limitations for the voucher. Big problem that was not foreseen with 899, or 899 when we created the voucher. I think actually it was the prior statutes, 246. The voucher didn't have a time limit. So someone who became eligible for them, the voucher would be good for the rest of their life. And I used to say that, I used to handle cases involving bus drivers. Bus drivers that had 10, 15 injuries. For every one of the vouchers they'd had, they'd just take it, throw it in a drawer, and when they retired, they could open that drawer and say, oh, I can go to Stanford now, because I've got 15 of these $4,000 vouchers. So they never expired. We now have a statute, so for every voucher that issues after 1/1/13, this is not based on date of injury, it's based on the issuance of the date of the voucher. Every voucher issued after 1/1/13 has a statute of limitations. It's the same as vouchers for injuries after 1/1/13, and it's 2 years from the date that the voucher is issued and up to 5 years from the date of injury, whichever is later. So we now have a time limit within the voucher, time the voucher has to be used, and it must be used by the injured worker requesting or incurring the expenses within that time frame. They can't hit the end of the 5 years, be it 4 years, 10 months, and say, oh, I'm entering school next month. Please, I'm going to send you the information for the voucher. Doesn't work. They have to actually incur the expenses within the 5 years. Now, there's a couple of other things. Injured workers have a right to simply ask for a $500 advancement on the voucher. Okay? So they don't have to show that that's going to be part of so they don't have to present receipts. They can just say, I have an emergency need for $500 to use out of my supplemental job displacement voucher. Theory, it's supposed to be for a vocational purpose. I'm not sure how that's going to work. And there's a specific provision that they can use up to $1,000 for a computer. And at least in the preliminary rules we've seen from the DWC, that includes peripherals, software, printers, and everything basically you need in order to make a computer work. But it can't be games, just so you all know. It's specifically in the regulation that it can't be for games.
This is a real problem because, look, I think that what they've done is they've really screwed up the voucher for us. Excuse me. They've really screwed it up because now everybody wants the money. So everyone's going to want to use the voucher at least to some extent. With the ease of getting $500 or $1,000 for a computer, voucher is going to be part of our lives, I think, to a much greater extent than it ever was. The current regulations, proposed regulations, would try and limit the use of the $500, just give me $500, to people who actually demonstrate that they're going to use the voucher in some educational way. We'll have to see how that plays out. But this along with, I don't mean to step on your toes, but there's another rule that says that you can't settle the voucher. And when I saw that, I said, did we learn nothing from vocational rehabilitation? I mean, we can't settle the voucher. How long do we have to leave our files open? It's a real problem. You can't settle the voucher at all. I really feel that vouchers, this is one of the things that hurt us in this bill. The extended use of the voucher is going to be just a thorn in our side to some extent.
Well, again, keep in mind, this is a benefit that is rarely used. I always tell people that when I have my injury, I'm going to use it to go to the Greg Norman School of Golf because it just says skill enhancement, and Lord knows I can use that skill enhancement. But it doesn't have to be for vocational purposes. It's a practical matter. It wasn't used. So this creates some additional rules. We also have questions, can you use it out of state? Because it's always state-approved vocational schools that you can use it in. So there's some limitations there that don't exist under the current regulations. So the question is, why was it done? And we've kind of alluded to that. And labor was dissatisfied with the fact that this is a benefit that people didn't use. You had to wait until somebody was permanent and stationary before they could actually access the benefit, before the voucher was offered to them. And basically, it wasn't something that was beneficial. So labor wanted to create it more accessibility, which they did by making it available earlier. And labor and employers wanted something that was more defined, a single level voucher. We don't have to worry about what the level of permanent disability is. The rules for making the job offer for alternative or modified or regular employment are easier under these provisions. Your time doesn't really run until you get a medical report that allows you to make the offer. So you have some more time than you did on the others. And I think employers, at least the people who perceive this, was that we were adding $2,000, $3,000, sometimes $4,000 to settlements just to cover the cost of the voucher, and that they solved that problem by creating a statute of limitations, which means that it expires at some point, and therefore you don't have to make it able to settle. I'm sure that within the, when you have cases under the, where you have injury AOEC, where the same issues that we had for voc rehab where you could settle, you're going to be able to settle the voucher in that circumstance. I think all that case law involving voc rehab settlements is probably going to be revived, the old Thomas findings, and we can use those things to settle it in disputed injury cases. It's just going to be in the regular routine admitted injury case that we're not going to be able to settle it. So one of the things, the next section we're going to talk about is this independent medical review for medical treatment disputes. This is one of the truly revolutionary, at least for California, because this is not unique to workers' compensation, it's unique to California. Other states have done this. And this is a process for resolving disputes between injured workers and their physicians and carriers over treatment that has been denied, delayed, or modified in the employer's utilization review program. And it pulls it out of the litigation system. So certainly in litigated cases, this is going to take the decision-making process away from the Workers' Compensation Appeals Board and require that medical decisions involving medical treatment will have to be decided by physicians. So at least within California, this is kind of a revolutionary concept, that we no longer let judges basically decide cases, although one of the things we have to keep in mind, for technical deficiencies, untimely utilization review in particular, this process may not be applicable. So it's going to be something which is going to require timely utilization review in order to trigger it, which I think for the most part we probably get. I really don't see a whole lot of late utilization review decisions. It applies to injuries on or after 1/1/13, but as of July 1st, 2014, it applies to all delayed, denied, or modified utilization review requests from that day forward. So it will be applicable to all existing cases as of 7/1/13. So the entire process will follow, and then up until then, from 1/1/13 until 7/1/13, we're going to be using the traditional medical legal process to resolve utilization review disputes, but should have huge decision. Now keep in mind, the only one who can appeal an adverse utilization review decision is the employee. The employer doesn't get to, it's your UR, you don't get to appeal adverse UR determinations, only the employee does. So how does it work?
You know, I wanted to say, we all know how it works, right? They submit a request for medical care, UR reviews it and denies it, then what do? They go to the AME or the QME, it takes 6 months, it needs to be a deposition, it takes 6 months, you go to court, and the judge looks at it and goes, I rule for the applicant a lot of the time, right? So this was one of the main things that we wanted to get done with this bill, which was to stop this, because it's stupid to have judges and medical legal doctors resolving these issues. It's time consuming, it's expensive, and it arguably hurts the applicant. So by taking it out of the system altogether, we hopefully have created a fast, efficient, and results-oriented procedure. We've taken it out of the hands of the workers' comp system and put it in the hands of a group of doctors. So hopefully this will really change things in this area.
Well, what the goal here is to have this handled administratively rather than a litigation process. So the administrative director is to create this independent medical review process. And there's a lot of statutory language involved in this that allows the AD to start doing this right away. Because ordinarily when you create this system, it has to go through a bid process, they have to create regulations. There's a lengthy, complex process for the state to be able to contract with somebody to do this. We've got a statute that says the administrative director can simply utilize the existing system that we have operating under the Knox-Keene Act for independent medical review of medical determinations. And there's already a process. Now, they handle 1,500 a year. We're going to get 1,500 a week, or maybe a day. Who knows? It's going to be, we'll do it a lot more than they do under the Knox-Keene Act. But the appeals will be administrative. When the UR determination goes out, the employee gets with it a form that literally all they have to do is sign the form. It's all completed by the employer. Sign the form, put it in an envelope that the employer provides that is pre-addressed to the administrative director. The employee will have to put their own stamp on it, send it off to the administrative director, and that's the appeal. And then there'll be a series of regulations, and this is one of those things where the devil's in the details. The regulations will identify when the insurance carrier claims administrator forwards the information to the identified utilization review determining entity, because the AD at some point will probably have multiple companies that do this. They'll assign an individual company to do a review in a specific case and rotate it and have a process for doing that. You'll send information, the injured worker can send information to the employer and say, we want this to go along with it. So I envision injured workers doing internet dumps to send, everything that they ever could find on WebEx and everything else, and we'll see how that gets handled in the rules, because that's going to be important. There'll be a fee that the administrative director is to identify that will cover not only the fee to the independent medical review company, but also to pay for the costs of the system. So this is going to have costs. It doesn't have to be the same fee for every case. They can scale it based on the kind of review and based on criteria they can identify. In this case, the fee is paid entirely by the employer. The employee does not pay the fee. There's no provision for the employer getting the fee back. So this is one of the issues that's coming up, but one of the things that you also got was, if it turns out that the requested treatment is not authorized and the employee obtains it anyway, there's a specific statutory prohibition that says you're not responsible for the treatment. So we have some helpful language. By the way, if the treatment is provided and utilization review, IMR indicates the treatment is to be provided, then yes, you will pay for it. So, but if it's disputed and the injured worker gets it anyway, you're prohibited from getting it. So these decisions will, by the independent medical review consultants, will be decisions of the administrative director, which are then appealable to the Workers' Compensation Appeals Board, but only on a very limited basis. So the limited basis are identified in statute, and they're in the, actually the next slide. So for instance, the administrative director acted without or in excess of the administrative director's powers. That might be reviewing a UR appeal that's not timely, because if it's not sent within the 30 days, it's not timely, it becomes final. So that would be something the administrative director doesn't have the power to do. An employer would have the power to appeal that and say this was not timely filed, therefore it's not valid. You should be able to win on that. The last one is the key one. The determination was a result of a plainly erroneous express or implied finding of fact, provided that the mistake of fact is a matter of ordinary knowledge based on information submitted for review pursuant to section 4610.5 and not a matter that is the subject to expert opinion. Okay, what does that mean? What it means is that the judge can't review the case and make a medical decision. So an example of that would be is an applicant has a request for carpal tunnel surgery by his doctor, goes to utilization review. The UR doctor says, we don't think this is medically appropriate. We deny the request for authorization. Applicant timely appeals, goes to independent medical review. Independent medical review says this is not a valid request. It's not medically indicated to do surgery because the applicant doesn't have a positive EMG study that's really necessary in order to determine that they actually have carpal tunnel. Applicant appeals it to the board. And in the appeal, they say, wait a second, I have a positive EMG study. They missed it. That's a plain fact, available to anybody who can read it. The report's in the file. It says, I had the EMG, therefore the decision is not based on the correct medical record. A trial judge can say, yes, you're right, but he can't award the treatment. All the judge can do is send it back to IMR, tell IMR you were incorrect, redo this. Either the same IMR company with a different reviewer or a different IMR company reviews it and looks at that EMG study and issues a new decision. Now, the new decision doesn't have to be, yes, you get the surgery. The new decision may be, we've looked at this tracing, and we don't think that this is a positive EMG. We think that the neurologist who evaluated this for the doctor over-interpreted the EMG, and this is really not a positive finding, and therefore we are not going to authorize the surgery. Now you're done, because now it's a medical issue. You can't take it up and say they were wrong in their interpretation of the EMG. That's a medical decision. Only the UR doctor or the IMR doctor can make the medical determination. The trial judge can't reverse it on that basis. So this is going to cut down on litigation over reviews of independent medical reviews to a great extent, because there's not going to be any point in it, or it's going to be a relatively easy thing to argue.
It's a key facet of this whole setup that you just can't appeal it. Because if you can appeal it, but only under very, very limited grounds. Because if you could appeal it, what would happen? Well, the judge would be deciding it, right? And then we're right back where we started. Another aspect of it is that the independent medical reviewer, and I love this part, is secret. Okay? It's like a secret evaluator who issues the decision. So charges of bias, fraud, conflict of interest are going to be very, very difficult to prove. And that is probably going to lead to a constitutional challenge on at least this aspect of it. Whether or not they'll be successful is, in my mind, highly doubtful.
Yeah, so as to why this is done, I think is pretty easy to understand. This is to reduce litigation over medical treatment, to take the decision-making process on medical treatment and put it in the hands of physicians instead of judges. And the final analysis, I think what this really is intended to do is to make workers' compensation medical treatment look like group health medical treatment. Because labor buys group health medical treatment. They understand how group health works. And when labor negotiates for group health, they negotiate for everything they can to bring the cost of group health down. They don't want to pay more costs than they have to. They understand that medical care is expensive. Now, remember I said that before 1991 we didn't have reform. Up until 1991, everybody who was negotiating over whether we increase benefits assumed that workers' compensation benefits were free. Nobody paid the bill. We know that's not true. Somebody paid the bill. But we didn't recognize that the people who paid the bills didn't have unlimited resources. We assumed workers' comp was an unlimited benefit. Medical care was unlimited. In the last 15, 20 years, we've cut down on the concept that medical care is unlimited and realize medical care is a limited benefit just like everything else. It costs money. There are things that should be done to make certain that medical treatment that is provided is appropriate, and that the litigation process is not really a good way of resolving these issues. You rarely ever go to litigation in the group health setting. Very rarely do you ever see that. California Comp, as soon as you get a UR denial, the next thing I would get in my case is a request for an expedited hearing by an applicant attorney saying, we want the judge to award this treatment. Half the time we go down there and say, you never appealed the UR determination, you're not entitled to a hearing. And we'd have to go off calendar and figure out how to do the thing. So this should eliminate a lot of those spurious and unnecessary hearings from that standpoint.
That's right. We're going to stop the madness, hopefully. Stop the madness in regards to having the Workers' Comp Board deal with these issues. Another area that we're going to do that with.
I just have one more comment on the other huge benefit, and this is one that I think is frequently overlooked, it's certainly overlooked by applicant attorneys, is that you're going to get a relatively fast determination over what medical treatment the injured worker is entitled to. So the IMR determination is going to be out 35, 40 days after the UR determination is made, and as a practical matter, you're going to have decisions made promptly rather than taking 3 months, 6 months, 9 months, a year sometimes to get a final determination as to does the injured worker get this medical treatment. So ultimately, one of the beneficiaries of this is not just you who are paying the bills, but injured workers who are getting prompt, more expeditious determinations of, is this reasonable medical treatment? Should I get this medical treatment? Or is this unreasonable, unnecessary medical treatment? I think that that's one of the things that we have to look at as one of the strong positives to this.
Okay. Another area that we want to stop the madness, and I think hopefully we have, is the area of liens. Okay, liens we all know that liens are driving Southern California down right into the dirt, and something had to be done. A big part of that was disputes over the reasonable value of medical services. I mean, we all know how it works, right? A doctor sends a bill which is 3 times the RVS value and has some creative coding and has just all these reasons why they want to inflate their bill, hoping that the claims adjuster will simply pay it, and sometimes that happens, right? We send an objection, and then everyone goes to court after the case in chief is resolved, and we fight for a long, long time over all the liens. And the judge, of course, is looking at it going, reasonable value of liens, RVS codes, I don't know what to do with this, settle this thing, or I'm going off calendar. And that's our world, isn't it? We pay too much, we all engage in advocacy on both sides, and we have a long, long time and a lot of litigation expenses. So just like with IMR, IBR, independent bill review, is designed to get this dispute out of the system and into the hands of RVS experts who, like with IMR, can't be appealed, and thus eliminate all of the problems, the entire culture of disputes over the value of medical services, and that's what IBR is all about. It's an administrative system, handled by the administrative director. But just like with IMR, the dispute after a process we'll go through now goes to the administrative director and then goes to an independently contracted reviewer for resolution. How does it work? Well, there's an underlying new system for disputes over bills before you even get to IBR. And the great thing about it is it's designed to eliminate all the bad motivations that exist in the system. If you end up going to IBR, whoever wins doesn't pay. Whoever loses does pay. So along the way, you're kind of looking at that IBR that's coming going, do I want to be the loser in the IBR process? No, I don't. So now I'm not going to inflate the bills. It's not going to be in the hands of a judge. It's going to be in the hands of an independent reviewer. So if I'm a lien claimant, I'm less inclined to inflate bills. If I'm a defendant, I'm more inclined to kind of think about what's reasonable, what's not along the way. And there's a 4-step process that gets you to IBR. First, the bill is sent. There has to be an itemization. And there's got to be all the materials that go with it. Second, we bat it back into play, and it's a new burden on claims adjusters, and we have to say why we don't want to pay the parts we don't want to pay. We have to give an itemization. We have to be specific about what we don't want to pay and why. And then there's a second review that comes, which is the third step in the process. And if they don't do the second review, the bill's settled. If they do the second review, they have to tell us why they think they should be paid more money. And finally, we have to respond to the second review. So in all 4 stages, we all have an opportunity to take another look and go, is this right what the other side is saying? And do I want to go to independent bill review or not? Because like I said, the bill is going to come due for whoever's wrong in IBR. And that's how it works. There's 2 chances for a lien claimant to lose their bill along the way. One is if they don't ask for second review within 90 days, and 2 is if they don't ask for independent bill review within a 30-day period. If they don't take that action, the bill's gone.
Now, this is a huge part of this, because one of the enormous things is in order to file a lien claim and dispute over the amount of a bill, you must go through this process. So at 90 days, if they hadn't filed the request, they're done. They're out. There's no more, they're no more arguing over the amount of that bill. If they do make the request within 90 days and they don't make the request for independent bill review after 30 days, then they're done. There's no more arguments over. So this is designed to allow medical providers to raise legitimate medical disputes where there's a clear, where the parties can't agree on how the fee schedule is supposed to be applied, whether the services were properly coded, whatever the arguments are, have an independent party not hired by the employer make the decision, and then you're done. And if they don't, but it's to be done promptly. So you're not going to be coming back 2 years from now and saying, oh, by the way, we meant to have you look at this bill again. And I've seen that. I actually had a case where I got a request from my client got a request from an ambulatory surgery center, requested consolidation of $7.2 million in bills on 728 different bills. They wanted to file it in one case and asked the board to adjust all these bills. So my client had paid almost all chunks of these bills based on fee schedule. They're asking for another $7.2 million. Some of these went back into the late 80s, all the way up until the latter part of the 2000, about 2008, 2009. So we had like an 18-year period of time that they were going over, trying to go back and say, we think all these bills were improperly paid. Well, with this stuff, you won't even have to worry about it. These provisions, you're not going to have to worry about this issue.
That's right. Now, the way it works is if any portion of the bill, let's say you go to IBR, okay? Now, if any portion of that bill is payable over and above what you paid, then the defense has to pay the IBR bill. So if we haven't paid the whole amount that's due, that's found to be due, we have to pay that. So are we going to be more inclined to pay the few extra cents or dollars? If in doubt, we'll probably pay. On the other hand, if nothing more is found to be owed, then the bill collector has to pay the IBR fee, whatever that happens to be after the administrative
No, they don't get it reimbursed to them.
Right, they
That's
don't
what
get it
happens. They have to
reimbursed,
pay it to file the request.
Right. So you see how all the motivations have changed here? They don't want to inflate. We don't want to unreasonably contest. Nobody wants to go there. And so probably a lot of cases won't even get to IBR, hopefully, if everyone does their job correctly. So it's a big change. And then the grounds for appeal are the same as IMR. So fraud, conflict of interest. The IBR person is not secret. but the rules are the same. So the appeals are very, very difficult, and the cases should stay outside the WCAB. Even if it is appealed successfully, it goes back into IBR again, just like with IMR. So never shall a judge make a decision. Always it shall be outside of the workers' compensation system. Hopefully this will really streamline.
By the way, well, there's probably a fair amount of controversy over IMR and whether that's, applicant attorneys don't like it. It takes their ability to litigate the treatment issues from the WCAB. Almost nobody that I know of is really objecting to this process. Certainly, attorneys are not, because when I go down to the appeals board and somebody wants to argue fee schedule to me, my eyes glaze over. Okay, the judge's eyes glaze over. The representative from the lien claimant may have an idea, but half the time they're basically an office clerk sent down to see if they can negotiate something. They don't know about the fee schedule. So we have 4 people in a room talking about a fee schedule that nobody knows how to interpret. So taking this away from the appeals board makes a lot of sense because the board doesn't know what to do with this stuff. And even when we litigate it, we have to bring in experts to tell us what this means. Occasionally we have competing experts, but the reality is the independent bill review will probably, for medical providers, give them a much faster, more efficient, more accurate, and certainly less expensive from their standpoint, as well as everybody else, ability to resolve these kind of issues. So this is one of the areas that I think there's almost universal. The only people who are really going to complain about this, lien representatives.
Collectors, yeah.
Because it's going to take away the...
we're going to get into reduction in liens in more depth now, but I also wanted to point out, and I think this is very, very important, that the way this is set up is designed to stop liens before they're ever filed. And here's how that works. If you have a threshold issue, before you get to the issue of what is the value of the medical services, like you denied the case, like you denied the body part, like is the applicant properly in the MPN, then IBR is deferred until such time as you resolve that threshold issue, okay? But then once you get done with the threshold issue, IBR comes back into play and you're out of the board environment, which is important. And this is the key, is you're not allowed to file a lien unless you are protecting yourself from the statute of limitations violation. You're not allowed to file a lien at all until IBR is completed. So since the threshold issues are taken care of before IBR, and then IBR has to happen before you can file a lien, and IBR resolves the last issue, which is the value of the services, why would you ever file a lien? And the answer is you're not going to, unless you have a threshold issue and a statute of limitations concern. The liens simply are not going to be filed. It's not going to be allowed. And so you see how that transforms the lien reality in Southern California especially. If it works right, it really should turn Southern California into Northern California in terms of the frequency and intensity of liens.
And actually, it's even better because the independent medical review, which has to be performed before the independent bill review, also can be deferred until nature and extent of injury or injury AOAC issues are resolved. And once those are resolved, to the extent that they're resolved where yes, you owe benefits, now you're into a retrospective review of medical treatment, or if a new request comes in, prospective review. That has to be completed to determine if the treatment's appropriate. If the treatment's not appropriate, they're not entitled to file a lien claim. If it is appropriate, then they go into independent bill review. So it's all staged so that the lien should not arise until you have an issue after independent bill review, and you can't file a lien after independent bill review over the amount of the lien because that issue is resolved. It's done.
It's really great. And the last point I wanted to make before we moved on to lien is what about all the ancillary stuff? What about interpreters and copy services and home health care and vocational evaluations and all the things we see that become lien claims other than traditional medical care with physicians? Someone asked me that the other day, and I went like this, and I went back and looked carefully at the law. And what I realized is all those things are usually characterized as either medical treatment or medical legal in one way or another. They're always attendant on one or the other in almost every case, except for some instances where they're litigation costs. And what that means is that all of this is going to be included in IBR. So everything that's not just a straight litigation cost, all of the things I was talking about, well, that all goes through IBR as well. So this whole world of liens, there's not a whole lot of exceptions. This whole world of bills, there's not a whole lot of exceptions. Everything you're confronted with someone wants to get paid that has to do with treatment or med legal, even if it's just an attendant thing, is going through IBR, which makes it a very broad and encompassing reality for us in the lien environment.
Okay, lien reform. This is probably the one that, in many respects, have Michael and myself the most excited. More Michael, because I'm in Northern California. We don't have some of these issues anywhere near the extent in Northern California they do in Southern California. But we have also in Southern California, we have many Southern California clients. So this is going to be huge. We have new filing requirements. So liens have to be filed electronically. They have to have the supporting documentation with the lien claim. They must be filed with the lien activation or lien filing fees. We've got new statute of limitations, notification requirements for representation, a lot of more restrictions on how lien claimants function and file their claims for benefits. The filing fee for liens filed after 1/1/14, regardless of the date of service, there's a new $150 filing fee for most direct medical providers. The exceptions on this include, like EDD is not going to be filing lien fees. If Blue Cross files a lien fee, they're probably not going to represent it. If they're a group health provider for the employer, they're not going to file a lien claim. Group disability carriers. The Medi-Cal is not going to have to file lien fees. The Veterans Administration won't have to file lien fees. But your direct medical providers, which is the overwhelming number of medical providers in the state, interpreters, physical therapists, pharmacy companies, all of those providers are covered by the lien filing fee. If you don't file the lien fee when you file your lien, the lien is rejected and deemed not filed. For liens prior to 1/1/13, in order for the lien to be active after 1/1/13, they must have filed a $100 activation fee. Unless they previously filed it, because remember back in 2003, we had a lien filing fee that was then eliminated. So if they filed that already and it's on file, they're okay. But if they haven't, they must file $100 for a lien activation fee before they can have their lien heard at the Workers' Compensation Appeals Board. So if there's a declaration of readiness to proceed filed after 1/1/13, the fee must be paid with the declaration of readiness to proceed. If the case goes on calendar after 1/1/13, all lien claimants in a lien conference must have filed the $100 activation fee or the lien is dismissed, regardless of whether they filed the DOR. So if one lien claimant files a request for hearing, the case gets put on calendar and there are 17 other lien claimants. All of the lien claimants who show up who have not filed their activation fee at the time of the lien conference are dismissed by operation of law. They're done. They're cooked. So this should eliminate a lot of liens that, first of all, people really aren't pursuing, or they just filed it, maybe they already got paid, or maybe they don't think they have a realistic chance and they're just kind of hanging on, waiting to see if maybe somebody will offer them some money. Those people are going to be out of luck. And if activation fees are not paid by 1/1/14 on any lien claim filed before 1/1/13, so if it's after 1/1/14, they have to file the $150 fee. If it's a lien that exists as of 1/1/13, and as of 1/1/14 they've not paid their $100 activation fee, those liens are dismissed by operation of law. So they're gone. So this is intended, I think, as you can imagine, to get rid of lien claims. I mean, this is a lien claim. It's a put up or shut up issue. You either activate your lien claim, pay the $100, and try and get your money, or if you're not, and remember, lien claimants can't file a request for hearing until the case in chief is resolved. So if the case in chief is not resolved, they still have to file their $100 activation fee in order to keep their lien alive for post 1/1/14. So this is intended to make, if you want to pursue your lien, you've got to take positive steps to do so.
Yeah, this is already having an effect, right? I mean, like you said, we have it down here. We had Lienageddon a couple of weeks ago where we handled 50, 70 lien appearances in a week. And what was the driver of a lot of attempts to settle? The activation fee. They're not going to get it back, as Jake's going to explain. So they don't want to pay that activation fee. So this 500,000 plus backlog of lien claimants, we're seeing this rush to clean it up. And a lot of it is motivated simply by the fact that it's not worth it for them to file a $100 fee just to keep their lien alive. They want to settle now. And I think that this particular provision of the changes is designed, at least in part, to enforce a strong cleanup presence clean up a reality in Southern California with the existing backlog of liens.
Yeah, one of the other things we have that's extremely beneficial is what appears to be a pretty clear, pretty definite statute of limitations. Now, we have a statute of limitations now, but we had issues about, does the statute apply when you've received notice that maybe a medical provider disputed your payment on a bill, but they hadn't filed a lien claim? What were their rights? And there was some case law that said that if you had notice, that you had to give them notice when the case settled, give them an opportunity to file a lien claim, and if you didn't, then you did not extinguish their rights when the time limit's filed. None of that will apply after 1/1/13. And keep in mind, this is effective for all claims, regardless of the date of injury, as of 1/1/13. So this new statute will apply. They've actually made it two specific provisions. For liens filed before 1/1/13, a lien for medical treatment cannot be filed more than 3 years from the date the services were provided. So up through 1/1/13, they have to file the lien within 3 years. So as of January 2nd, 2013, if a medical provider says we provided services in 2010, they're going to be out of luck. They're not going to have a chance to get their lien claim on file because they're going to be beyond the statute of limitations. After July 1st, 2013, the time shortens even further, where they must file the lien within 18 months of the date of services. So this is going to prevent medical providers selling off their book of business to somebody for 10 cents on the dollar, saying, go ahead and see if you can collect any of this. We don't care. We wrote it off. And we've seen that happening. We've seen that happen in the past.
Yeah, I think it may actually have an effect, not just on barring entire liens, but parts of liens. Let's say you did service for 10 years, right? And you didn't file the lien until the end. Well, this is a retroactively applied statute. And it only allows for services that were performed within 3 years of the filing of the lien, see? So what happens to the other 7 years? Arguably, they go away. That's a really significant change. We were talking about activation fees and filing fees, and we said, hey, if you don't have that on file, then the lien is not deemed filed. Well, who cares? Well, now we care, because the statute of limitations is not a sieve anymore. Sieve, or how do you say it? The thing with holes in it, all right? It's
colander.
tight.
It's not a colander.
Thank you, yeah. Look, it's going to have a significant impact on the whole package, all interlaces together to have a significant impact on both past and present liens.
Yeah, and even though these time limits don't apply to the group health providers and group disability providers, they do have their own statute that will apply and doesn't allow them to come with an unlimited time frame. And it's basically a year from the time that they know or should know in the exercise of reasonable diligence that they should be filing, that the benefits are provided for a work injury. So they don't have an unlimited time frame, but their time frames are a little bit looser, and theirs is a know or should have known as opposed to date of service provision kind of statute.
Okay, the next area that we're talking about with liens concerns some other procedural changes designed to stop some specific bad behavior. Let's say that you paid per RVS in 1982, okay, and now an entrepreneur comes along, talks to the doctor and says, hey, I'll buy all these liens from you. My name is Fred, and then you go to court and you're talking to Fred. It is a lien claim, it says Fred on it. And you're like, Fred, you're not a doctor. Why am I paying you? Why are you the lien claimant? And we have this world of lien assignments, of opportunism and entrepreneurship, right? Depending on whether you want to be nice or mean. That's what's happening in the workers' comp system. So they made a rule restricting the assignment of liens. It's the doctor who has to be the lien claimant and has to be paid unless that doctor's not practicing anymore as a doctor. And if there is an assignment, then that has to be identified to the board. So it sort of stops this whole scheme right in its tracks, doesn't it? That's not allowed anymore. Also, no longer can you just show up at the board and say, I'm Fred the representative, or I'm Fred the lien claimant. There has to be a clear understanding about who's the lien claimant and who's the representative of the lien claimant. And that doesn't sound like much, but at the board it's a big deal because there's this constantly shifting reality about who's representing the lien claimant, proofs of service, all kinds of logistical problems. So they've made it a rule now that there has to be reasonable notice to the parties. It says within 5 days of asserting representation on a lien claimant. And finally, another change was a restriction on entitlement to medical information. This is a privacy concern. This is about privacy. Applicants' medicals tend to kind of go everywhere, right? And we have the Employer's Bill of Rights, and we say what the employer can and can't get. Well, now they're saying that non-physician lien claimants can't get medical information either. So that's not something that really impacts us so much as protects the applicant's privacy, although it's something we'll have to make provision for in our procedures.
But it was also one of the things that came up where a lien claimant would say, okay, you're not going to pay me my lien. You need to serve me with an entire copy of the medical file. And if you don't do that, I'm going to argue to the judge that you've waived your right to litigate this lien because you haven't done what you're supposed to do, which is serve me with a copy, and I'm prejudiced. Well, that's not going to arise anymore. A copy service is not entitled to a copy of the applicant's medical records. If you're a group disability provider, you're really not entitled to that. So this is to prevent lien claimants from overreaching as on a tactical basis, saying we want to get copies of everything that you have in the file, which means you've got to go copy this much stuff and send it off to them. And they'd also say, and we want a copy of your UR plan, and we want a copy of your bill review plan, and all this stuff that they'd say they'd want. This limits how much they can request and what they can get.
All right, so wrapping up lien reform, we've talked about it as we've gone along. This is a systemic approach to elimination of lien culture. And unless I miss my guess, to a large extent, it's going to work. Because everything we could think of to plug holes in the lien practice has been instituted. Lien litigation in Southern California is a crippling reality, as we all know who practice here, right? I mean, they set aside cases in chief for long periods while they have lien conferences and they try to deal with the backlog of liens, but it doesn't matter because they're already generating more. And 500,000 existing lien claims. How do you deal with that? Well, I think as we've presented, it's coordinated with IMR, IBR, limitations on when you can file, fees, standards. Hopefully this will do the trick.
But you're going to say what zombie liens are.
I was going to say what zombie liens are. Zombie liens are it's a funny term that we use to talk about liens that have come back from the dead and are trying to eat us, right? Zombie liens are liens where we paid, like I was saying, RVS, right? And now the lien claimant says, I can allege that RVS wasn't paid properly and more is owed. No matter how long ago this happened, I can do this. I'll come to court, I'll file a lien, I'll say it's worth 3 times what it's worth, and then I'll make you negotiate with me, otherwise I'll take you all the way down to the trial process. And these are zombie liens, and they're a real annoyance, because you thought your case was closed, and now it's open again. And you either get extorted and you pay or you don't. Well, there is a series of statutes, and I won't get into it here, but there's a series of statutes that's operated under some case law to allow these sort of liens to bypass the statute of limitations. Those statutes have been amended. And no longer can these zombie liens exist because they're too old now. And if they don't comply with the current statute of limitations standards, they're automatically dead. And this does take care of a big chunk of what we're dealing with in terms of not only the expense, but just the unpredictability of the reality of liens in Southern California.
Now, I had one lien claimant tell me that I make my living on the chaotic fringes of the workers' compensation system. This looks like it's intended to eliminate the chaos and the fraying. And I said, you're exactly right. This is intended to create a system where in 3 years you have nothing to do. And I think there's a pretty good chance that substantially that's going to happen, that we're going to see a whole different process. And in 5 years, we may see Southern California looking even cleaner than Northern California, even though that's probably not possible.
Well, also there's the attendant litigation that comes with lien practice, right? The idea, and we're going to get into MPNs now, the idea that you just go out there and treat with whoever you want, they file a lien and you have to deal with it. And there's all the sort of weird issues that arise as people seek to be opportunistic within the confines, vendors seek to be opportunistic within the confines of somebody else's workers' comp case. Hopefully, not only will there be a reduction in lien litigation, but a reduction in the attendant litigation that always follows behind.
Okay, now we're going to talk about MPN reform. And this is one of those areas where we did a lot of little things to address little issues that have been kind of bugging us since 2004 with medical provider networks. So we have both issues that involve how MPNs are set up and administered, and then issues about what happens when you litigate over medical control. Okay, so the technical changes have to do with the liens or MPNs will be approved for a set period of time, 4 years. Existing MPNs are automatic that have been approved, have a shelf life, and you just have to refile again. We've allowed people who are other than employers and carriers to file MPNs. Our current system, you have to be an employer or carrier. Well, Sedgwick, in order to file MPNs, had to file it either on behalf of a specific insurance company or a specific employer. So Sedgwick probably has 70, 80, 100 MPNs. They really only have 4, but they had to file all these other MPNs. Well, this will save that. You can file 4. This is our Sedgwick, Coventry MPN, our Sedgwick Kaiser MPN, our Sedgwick Mixed Bag MPN, and employers will have the choice of them, and the AD won't have to review 45 MPNs that all look identical, go through them all, and make sure that they comply with the regulations. So this is a cost saver for the state and a flexibility issue. As of 1/1/14, physicians in the network must confirm that they are in a network and they know they're in a network. This doesn't apply to group practices, Kaiser, or maybe Sutter Health, where you have groups that are involved, but it applies to individual physicians. And this is the one I like, eliminates the 25% requirement for non-OC docs.
That was always
Now,
stupid.
I don't know if you know what happened. What that meant is that we had 25% of the docs in a network who didn't want to see workers' compensation cases. And then when employees would complain to the administrative director, they'd say, you have doctors who won't treat injured workers, and therefore your network is defective. But you have these doctors in because they required it. So they eliminated that provision. So they also, and this is an issue that's, I think, significant, as of 1/1/14, every MPN will have to have an access to care coordinator whose specific job is to assist injured workers at gaining access to medical care within the network. So the injured worker calls up the claims administrator or their attorney, or they're down at the board and they're saying, I've called 4 doctors in the network and none of them will see me. This is the person they call who puts it, when they get them on the phone and they say, I will get you a doctor in the network who would treat you. And they'll find the specialist to treat them. Or if they can't, they'll say, we don't have somebody and we're going to direct you to go outside the network. So you short circuit that process. So this is a particularly big issue from the standpoint of making sure that there's access to care. From the employer standpoint, we get some new tools for making sure that when somebody's in an MPN, we don't get leakage. We've plugged up some of the holes. One of the things used to be argued by applicant attorneys, they'd come in and say, or actually even more often by lien claimants, saying, well, you're asserting that you had medical control within the MPN, and what we want you to do then is prove each and every element of the MPN that you complied with all the rules and regulations and to show that your MPN was valid. You don't have to do that anymore. You have to show your MPN number. Now, we had some cases that said that, but the reality is that you'd go down to the board and you didn't know if you had Judge Goodhart or Judge Blackheart to tell you that you have to prove the MPN or not. This now makes it statutorily defined that as long as the MPN is approved by the administrative director, it's conclusively determined that that MPN is validly established. Also, the other argument that would be frequently made is if you didn't send one of the notices or you didn't post the notice that's required under 3551, that the employee could escape the network because you didn't give them a notice. What the statute says is the only way that that's a basis for escaping a network is as a result of not getting the notice, the employee did not have access to care within the network. Now, for the most part, what happens is the employee's in the network, they go to an applicant attorney who says, go see, Dr. Feelgood, my buddy who I play golf with on Wednesdays and Saturdays and takes me to ball games and stuff, and he's your new treating doctor. And the employee says, yeah, but I'm in the MPN. Says, don't worry, they probably didn't send you a notice somewhere along the line and we can get you out. Well, now that person had access. They weren't having a problem with finding doctors in the network. They were treating in the network. Pulling somebody out of the network in that circumstance and sending them to a doctor is not going to get you outside the network. And you're going to be stuck with it. And you are not responsible for that treatment that's provided outside the network if it's ultimately determined that the treatment that was appropriate within the network and you in fact did have medical control. So this was done for 2 reasons. Labor wanted better. They had complaints from their membership. The employers have MPNs, but we can't get to see doctors. It's designed to create better access to physicians within the MPNs. Keep in mind, the goal here is to make certain that people have access to medical care. It's an obligation of employers to provide. From the employer standpoint, you wanted to make certain that you could enforce the MPN when you had that contract and you were down at the board. And so it's to reduce litigation over MPN control. And then there's a whole bunch of provisions that are designed to give the administrative director more authority and more power to review, regulate, and discipline MPNs for not complying with their requirements in the statute. So that's potentially a big deal.
All right, our last area is reforms.
Second to last, but go ahead. You can do this really quickly.
I think I can because I have to, because we're almost out of time. The medical treatment reforms. There's some that are very, very important, and those include home health care reforms, and then there's some other changes too in terms of fee scheduling, which we'll get into. In regards to home health care, there's some very, very important changes. You know how the applicant has back surgery and the spouse cares for the applicant for 10 years and files $1 million lien?
Or 5.
For $100,000 a year, $50 an hour, right? Well, what they've done is they've said you have to have a prescription from a physician and surgeon
Yep.
that in order for this claim to be valid, and it applies retroactively, my friends. So you get those liens, you go back and say, was there ever a prescription? And until there was, what came before that is not compensable, at least in my opinion. I think that's a very, very significant change. Also along these lines.
By the way, it's also be subject to UR, IMR, and IBR. So all of the arguments over whether you provide home health care are going to be resolved medically, and how much you have to pay for it are going to be resolved by fee schedules.
Right. There's going to be a fee schedule for it, and all those other things apply. In addition to that, whatever services were provided by the spouse before the injury are not compensable after the injury. And that's also a very significant change. Hard to prove, but it's something we can certainly use on the defense side. Interpreting services have been changed. There's going to be now a certification process, or you don't have to pay the interpreter if there's not a certified interpreter by the administrative director. There's going to be a fee schedule for that. Also, there's a limitation on chiropractors as primary treating physicians. After the 24 visits, a chiropractor is no longer allowed to be a primary treating physician in a case. You know, there's a 24 visit limit for chiropractic care. After that, they cannot be a primary treating physician, which is a huge change, and something that we can apply right away on 1/1.
Keep in mind, that's only effective for injuries on or after 1/1/2004, when the 24 visit limitation went into effect. So you're not going to be able to cut off people who been treating since 1997, but you can do IMR and IBR for those things.
Right. I'm going to limit my comments on the next slide to fee schedules. In summary, you know, there's a lot of areas without fee schedules, right? And we don't know how to price things out. Copy services, home health care, ambulatory service centers, interpreters. For all of these things now, there will be fee schedules. And when the administrative director enacts it, then that's going to be it. So I'm going to skip this next slide, and you can give them, I think we have a minute left, so if you want to make one point about litigation changes.
Some interesting issues in litigations. One of the things that's been a holdover since 1991 is a provision that if the employer filed an application with an unrepresented worker, you're paying their attorney's fees. When that was passed in 1991, filing an application was like filing a request for hearing. It wasn't what we call filing an application. The jurisdiction of the board was obtained with a different form. So this was intended, if you're going to litigate the case, you have to pay the applicant attorney's fee. That provision has finally been removed. You can file an application, you can conduct discovery, do depositions of QMEs, depositions of injured workers, subpoena records, all of those things that you can do using the authority of the WCAB for injuries, for all matters after 1/1/13. So I know in 18 and a half years as a defense attorney, I've never filed an application with an unrepresented worker. Probably on January 2nd, 2013, I'll file about 10 of them. So I can do depositions and subpoena things and get stuff done, because otherwise you can't get things done. There's some changes in the medical legal process that we really don't have to go into, but the one significant one is the expedited hearing process has been expanded to include things like, is the employee in the MPN? You can litigate that at an expedited hearing. Does the employee, who gets to control the medical legal process? Who gets to designate the specialty? What's the appropriate specialty for a medical legal evaluation? Is now an expedited hearing process. I had a judge in San Jose said 25% of her hearings was over who gets to designate the specialty of a medical legal provider, and what's the appropriate specialty to examine the applicant. Applicants always want chiropractors and psychologists. Defendants want orthopedists and psychiatrists. It's just the way life is.
Okay, I think we're out of time, so we'll have to move on to letting Mr. Brown take control, I think. He's been hovering.
Thank you, Mike and Jake. We want to turn it over to the audience to see if there are questions that you have. We actually have 15 minutes for questions from our live audience.
We could have kept going.
And questions from our web audience.
They'll do anything to
Good try now.
So questions you have for Mike and Jake.
Thank you, panel. We do have a question from the web audience. This is coming from an employer representing the technology sector and would like to know whether the IMR process and the time frame that it will take to go through that process will create some delays in getting treatment approved.
Not as long as it's taken now. Okay? Right now, it is a nightmare. AME, QME process, and the court, which are really the two things that screw up our system, right? The med-legal process and the court. This is what causes the delays, that and surgery. So not as long. The big concern I have is the bottleneck possibly at the administrative director's office. There's time limits for everything else. When you submit it, how long they have to do it. But at the administrative director's office, when it gets backlogged, we've seen problems like with the panels and things like that. So yes, there will be some delays. Yes, I anticipate some administrative difficulties, but it's a lot better than what we've got now.
It's actually a much faster means of resolving the dispute. So you are authorized as most medical treatment. Most of the stuff I've seen go through UR gets authorized, or even if it's not, the doctor says, oh, I see what you asked for, I didn't send it, let me send this to you, and you get it authorized. So most stuff gets authorized. This is just for resolving disputes where it's not authorized, and it's going to be a much faster process than the medical legal process. And sometimes it's never, once the UR decision comes out, it's never litigated. The answer never comes out, and you get repeated requests for it and a lot of frustration. Here you'll get an answer. The other thing I expect to happen is I think you're going to see a change in behavior. If UR companies are consistently reversed by the administrative director and IMR, you're going to see employers and TPA saying, wait a second, why should we be using you? You have a 39% reversal rate on IMR. We think a more appropriate rate is 15%. So we're going to look around for somebody that has a 15 to 20% reversal, so we're not spending $300 or $400 on IMRs only to get reversed. So ultimately, it should affect behavior in terms of how you go out and manage and purchase UR services and decide who you use as a UR provider.
Yeah, intelligent use of UR has always been good practice. Now it'll be great practice.
More questions from the audience? We have a question. Okay, Karen.
As defense counsel, how do you think the culture at the appeals board is going to change given that their workload is pretty much going to be cut in half?
Who's? The defense attorneys?
No, there's just the culture down at the appeals board. You know, the judges, the
Well,
things that
what
you
we
can
saw-
litigate
What
are...
we saw after SB 898, well, first of all, it'll get cleaned up with less lien claimants around, right? So that'll be, an improvement. And then I think, after SB 899, what we saw is that the bottom third of practitioners kind of died on the vine, but the good ones remain. I think the litigation will be less frequent, but more intense. So you're going to need smarter lawyers and maybe a little bit of fewer lawyers. Hopefully there'll be an improvement in the overall quality.
Wait a second, no, it's not here.
What is that? Who was that?
I've heard mixed results from judges. I've had some, first of all, almost no judge is objecting to IBR. I mean, it's like a home run win for almost everybody. IMR judges, to the extent that they listen to the applicant's bar, are concerned that our injured worker is going to just be barred from getting treatment that maybe they ought to get. A lot of judges think this is really decisions they shouldn't be making, that it really is a medical decision. And even reading two medical reports, you say this one says you get it and this one says you don't. How do you make a judgment as to whether that's really the right medical treatment? And a lot of times they would simply err on the side of, okay, all things being equal, applicant gets her medical treatment. This is going to require treatment to be provided based on medical treatment guidelines, evidence-based medicine. If a doctor can't make an argument for the treatment to be provided based on the criteria that's identified in IBR, then or IMR, they probably shouldn't get authorization for it. So I think that it's going to have I think that's what you're going to see. I think most judges, as time goes on, will get used to the idea they're not litigating this. I think some judges are going to welcome it.
Another question from our web audience has to do with a large retail store chain that would like to understand if they have a customized MPN right now with their TPA, will they have to refile every 4 years for approval with the state?
Yes, that's a real easy one. You'll have to file every 4 years. You have to file 6 months before it expires. If no action is taken within 30 days or 60 days, it's deemed approved. But you will have to, each MPN will have to be refiled every 4 years. And that's just, there's a update the regulations. You're going to have to make sure your MPN is updated for whatever new regulations occur, but it's just part of the process now.
We got one in the back.
How do you think the independent medical review companies are going to be selected? And I know the administrative director has a say-so in that, but how do you make sure that they are really independent companies and not loaded with plaintiff doctors versus, how are you going to know it's going to be fair?
But, the independent medical review companies will ultimately be providing, responding to RFPs for their services. There's a fairly comprehensive conflict of interest provision where they have to identify all of their contractual relationships, who they do work for, in order that when the administrative director assigns a particular vendor, that they're not assigning them to somebody who did the actual UR determination or who has a contract with that employer, who may have multiple vendors with that employer or that third-party claims administrator. So there's a fairly tight conflict of interest provision in it. As to whether they're going to have a whole bunch of plaintiff's doctors versus, I've yet to see a UR vendor that has a whole bunch of plaintiff's doctors, so I'm not certain that that's a particular issue. The AD is not going to be doing this themselves. They're going to be contracting out. There's no provision that allows the AD to set up their own IMR company and funnel it through that. They're going to have several of them because IMR is going to be done a lot more under this process than it's done under the current program for the state managed care provision. So our initial contract will be with, very likely, the current vendor for the state, who probably has to ratchet up and maybe even subcontract out with some other vendors in order to be able to meet the demand. But ultimately, I think the AD is probably going to be looking at some quality assurance issues, which will certainly involve timing. For instance, one of the things we don't know that suppose the AD takes more than 30 days to issue the IMR decision. What happens? Now, I heard the administrative or the director of the DIR in one thing said, well, that means that the treatment's approved. I don't think so. I really don't think that's what's going to happen. Traditionally, when an appeal is not timely, it's denied by operation of law. So maybe you appeal that and get it sent back down because the AD didn't act timely. There may be issues with that, or there may be a process administratively to handle that. But in terms of who's going to be in the panels, individual companies will select the doctors. They have their contracts that already exist. And then the AD will probably have something that looks at quality, but I'm not sure how they're going to do that. We'll have to, that's an issue we've had with QMEs for years. We've never been able to resolve it. How do you make sure QMEs know what they're doing?
Regs are in the works. We need emergency regs for IMR to make it work. We can't really do it without regs. So we'll have to see. They'll probably add a lot to that discussion. Secondly, I also wanted to point out that as of 1/1/14, you can't both be in an IMR and be a QME. So that's one provision that's in the statute that will help isolate the two. Both for IBR and IMR, it's pretty clear that we also have these new conflict of interest, ownership restrictions, referral restrictions in the code. And all of these things seem to indicate that they want a clear delineation between people in comp and people in these separate, agencies, IBR and IMR.
Panel, our web audience would like some clarification regarding lien filing, and they're specifically asking whether the time restriction is 3 years from the date of the injury or 3 years from date of service.
It's date of service.
Yeah, service of the lien.
It's the medical service provided.
Right.
Is what we're looking at. So that's what triggers the time frame. So you do a physical therapy service on January 1st, 2011. It's 3 years from the date of that service. And so that's where Mike was saying that
You have to file a lien within 3 years from the service provided.
So if you do services for 7 years and you file a lien at the end of the 7th year, the services from 4 years back are going to be barred because they're not timely. So your lien will service both a statute on the lien and then a statute on services where the lien itself was not timely filed.
Which is going to think about that. I mean, what they've done now, the legislature, just like with home health care, they've come in and legislated away a whole bunch of lien value, right? Can they do that? They certainly can do that. Based on the cases that came after SB 899 in 2004, they can do that. And I really think that they have done it. We can go to these lien claimants and say, hey, the law changed, so anything before 3 years from the date you filed the lien, we're not paying for. And that's a they're not going to like that. That's going to take some getting used to.
Returning to the supplemental job displacement benefits, 2 questions. Number 1, clarification as to whether the trigger is at the evaluation of permanent and stationary status, or if it is at the point where a doctor is assessing return to work limitations and capabilities. And also, what is the time frame from when the employer has to issue that offer of employment? Is it triggered by the date of evaluation or the date of the report, or
No,
what is the time?
it's a much better environment now because it's not 30, you don't have to make the offer within 30 days of stopping TD, which was always silly because sometimes you stop TD and the person wasn't P&S yet. So that was always tough, but now they've made it 60 days from the date you receive a report in which all conditions are considered permanent and stationary. And the doctor has to send us a form. And if we don't get the form and the clock doesn't start ticking, that outlines the work restrictions, which I think is great because it's the only place I know of where we don't have to do anything unless we get a form. Usually other people don't have to do anything unless we send our form. So it's a refreshing change.
Well, I think actually what the requirement is that the employer completes a form that identifies the job duties, and the doctor has to respond to that form to trigger the time frame. Until you receive that, it isn't triggered. Or you have a report that identifies what the actual restrictions are that allow you to make a determination. So it's triggered from receipt of specific information as opposed to permanent stationary status or end of temporary disability. And then you have 60 days from that date, and if you don't make a job offer within 60 days of that date, then the supplemental job displacement notification is due 20 days after that.
Which is different because it used to be due once there was
Permanent, once the award came out.
Once the award came out, because you didn't know what the PD was, so it was 2,000 or 10,000, but now it's 6,000 for everything. So that makes it that they can make the issuance of the voucher a more defined time period.
Panel, our web audience would like a question answered regarding the fee schedule, and specifically where there is a code that isn't listed in the RBRVS, and you're dealing with by report or not otherwise specified. How will that be addressed now?
I'll let Mike handle that.
Thanks a lot, Jake. If it's not specifically in the RVS, the new RVS code, then I guess it goes back to Kuntz analysis?
I think we're going to wait for that's going to be at least addressed by regulation, I think. Because it's really not covered in the statute.
I'm remembering something now. If it's not, this is the new RVS is the code that Medicare uses, and I think if it's not coded in that new RVS code, then you analogize it to some other service and what Medicare would pay for that service. I think that's what the code says.
And that's how the code actually addresses that issue.
Yeah.
Saying that you look for something similar and you use that, but you'll get arguments over what's similar. You may have a medical provider saying, I think this is a closer analogy to that service than is what the UR company did, and it'll be up to IBR to make that decision, and when IBR makes that decision, then you're done.
So we have time for one more question. Terry?
Yes, I wanted to know, is the IMR going to make decisions on home modifications and van conversions?
That is a great question. I love that question because I've always said, how can you go to Kaiser Blue Cross and get a prescription to have your house built? How are we in this land in workers' comp? And the answer is the cases have interpreted 4600 that way, but I'm hopeful that we'll see these sorts of fringe services that aren't nationally recognized as medical treatment per se. I'm really hopeful that IMR is going to have an impact. They're going to look at that, and these non-comp doctors are going to say, this is not medical treatment. But it remains to be seen.
The reality is I think those things will be subject to IMR, and IMR will be the final determination as to whether that's appropriate. And the only thing I can see arguing to a judge about is if the IMR says this is not medical treatment, and a judge makes a determination that legally this can be medical treatment, reconsider it on that basis, then you may have an issue where they have to look and see, okay, is it medically, is it indicated? Somebody who's in a wheelchair should have ramps and the other ergo toys that you need in order to be able to function on a fairly routine manner. So I think those are the kind of things you're going to see people saying, yeah, that's an appropriate modification, but some of it we'll just have to wait and see.
Mike and Jake, thank you very much. Really appreciate it.